Acronyms: ABA, American Bar Association; ACA, American Correctional Association; ACJS, Academy of Criminal Justice Sciences; ACLU, American Civil Liberties Union; ADAM, Arrestee Drug Abuse Monitoring; ADMAX, Administrative Maximum; AEDPA, Anti-Terrorism and Effective Death Penalty Act, 1996; AFDA, Association of Federal Defense Attorneys; AFIS, Automated Fingerprint Identification System; AIDS, Acquired Immunodeficiency Syndrome; AJA, American Jail Association; ALI, American Law Institute; AMBER, America's Missing Broadcast Emergency Response; AOUSC, Administrative Office of the United States Courts; APPA, American Probation and Parole Association; ASC, American Society of Criminology; ASIS, American Society for Industrial Security; ASLET, American Society for Law Enforcement Training; ATF, Bureau of Alcohol, Tobacco, Firearms, and Explosives; BJA, Bureau of Justice Assistance; BJS, Bureau of Justice Statistics; BOP, Bureau of Prisons; BSEBP, British Society of Evidence-Based Policing; CALEA, Commission on Accreditation for Law Enforcement Agencies; CAPS, Chicago's Alternative Policing Strategy; CAT, Computer-Aided Transcription; CCA, Corrections Corporation of America; CDA, Communications Decency Act, 1996; CFAA, Computer Fraud and Abuse Act, 1986; CIA, Central Intelligence Agency; CID, Criminal Investigative Division; CJIS, Criminal Justice Information Services, FBI; CLET, Certified Law Enforcement Trainer; CODIS, Combined DNA Index System, FBI; COPS, Community Oriented Policing Services; CPOP, Community Police Officer Program, New York City; CRIPA, Civil Rights of Institutionalized Persons Act 1980; CRIPP, Courts Regimented Intensive Probation Program; CSA, Controlled Substances Act, 1970; CSC, Correctional Services Corporation; DEA, Drug Enforcement Administration; DHS, Department of Homeland Security; DNA, Deoxyribonucleic acid; DOJ, U.S. Department of Justice; DPIC, Death Penalty Information Center; DUI, Driving under the influence of alcohol or drugs; DWI, Driving while intoxicated; ECPA, Electronic Communications Privacy Act, 1986; EUROPOL, European Police Office; FBI, Federal Bureau of Investigation; FCC, Federal Correctional Complex; FCI, Federal Correctional Institution; FLETC, Federal Law Enforcement Training Center; FLIR, Forward Looking Infrared; FOP, Fraternal Order of Police; FPC, Federal Prison Camp; FTCA, Federal Tort Claims Act, 1946; GBMI, Guilty but Mentally Ill; HIV, Human Immunodeficiency Virus; IACP, International Association of Chiefs of Police; ICC, International Criminal Court; ICE, Immigration and Customs Enforcement; IDRA. Insanity Defense Reform Act, 1984. ILC. International Law Commission, United Nations. ILEA. International Law Enforcement Academy, FBI. Interpol. International Criminal Police Organization. IPS. Intensive Probation Supervision. JJDP. Juvenile Justice and Delinquency Prevention Act, 1974. JTTF. Joint Terrorism Task Force. LAPD. Los Angeles Police Department. LEAA. Law Enforcement Assistance Administration. LEMAS. Law Enforcement Management and Administrative Statistics. MCFP. Medical Center for Federal Prisoners. MDC. Metropolitan Detention Center. MPC. Model Penal Code. OPTED. Crime Prevention through Environmental Design. NAACP. National Association for the Advancement of Colored People. NACDL. National Association of Criminal Defense Lawyers. NCAVC. National Center for the Analysis of Violent Crime. NCCD. National Council on Crime and Delinquency. NCIC. National Crime Information Center, FBI. NCISP. National Criminal Intelligence Sharing Plan. NCJRS. National Criminal Justice Reference Service. NCPC. National Crime Prevention Council. NCSC. National Center for State Courts. NCVS. National Crime Victimization Survey. NCWP. National Center for Women and Policing. NDAA. National District Attorneys Association. NDIS. National DNA Index System, FBI. NFCA. National Fusion Center Association. NIBRS. National Incident-Based Reporting System, FBI. NIJ. National Institute of Justice. NJC. National Judicial College. NLADA. National Legal Aid and Defender Association. NOBLE. National Organization of Black Law Enforcement Executives. NVAWS. National Violence Against Women Survey. NVC. National Victims Center. NVCAP. National Victims Constitutional Amendment Project. NW3C. National White Collar Crime Center. NYGC. National Youth Gang Center. NYPD. New York Police Department. OJJDP. Office of Juvenile Justice and Delinquency Prevention. OJP. Office of Justice Programs. ONDCP. Office of National Drug Control Policy. PCR. Police Community Relations. PDS. Podular Direct Supervision. PERF. Police Executive Research Forum. PINS. Persons in Need of Supervision. PLRA. Prison Litigation Reform Act, 1996. POST. Peace Officer Standards and Training. PROTECT Act. Prosecutorial Remedies and Other Tools to End the Exploitation of Children Today Act. RICO. Racketeer Influenced and Corrupt Organizations, Statute. RISE. Reintegrative Shaming Experiments, Australian Institute of Criminology. RJC. Real Justice Conferencing, Pennsylvania, Release on Recognizance. ROR. Release on Recognizance. RTTF. Regional Terrorism Task Force. SAMHSA. Substance Abuse and Mental Health Services Administration. SBI. State Bureau of Investigation. SCU. Street Crimes Unit, New York City. SEARCH. National Consortium for Justice Information and Statistics. SNA. Software and Information Industry Association. STG. Security Threat Group. SVORI. Serious Violent Offender Reentry Initiative. SWAT. Special Weapons and Tactics. TFJJR. Task Force on Juvenile Justice Reform. TIPS. Terrorist Information and Prevention System. TWGEDE. Technical Working Group for the Examination of Digital Evidence. UCR. Uniform Crime Reports, FBI. USA. Patriot Act. Uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism Act, 2001. USC. United States Code. USP. United States Penitentiary. USSC. United States Sentencing Commission. VAWA. Violence Against Women Act, 1994. VCAN. Victims Constitutional Amendment Network. VICAP. Violent Criminal Apprehension Program, FBI. VOCA. Victims of Crime Act, 1984. VWPA. Victim and Witness Protection Act, 1982. Definitions. Abused child. A child who has been physically, emotionally, or sexually abused. Most states also consider a child who is forced into delinquent activity by a parent or guardian to be abused. Actus reus. An act in violation of the law. Also, a guilty act. Adjudicatory hearing. The fact-finding process wherein the juvenile court determines whether there is sufficient evidence to sustain the allegations in a petition. ADMAX. An acronym for Administrative Maximum. This term is used by the federal government to denote ultra-high security prisons. Administration of justice. The performance of any of the following activities: detection, apprehension, detention, pretrial release, post-trial release, prosecution, adjudication, correctional supervision, or rehabilitation of accused persons or criminal offenders. Point 2. Adversarial system. The two-sided structure under which American criminal trial courts operate that pits the prosecution against the defense. In theory, justice is done when the more effective adversary is able to convince the judge or jury that his or her perspective on the case is the correct one. Aggravated assault. The unlawful, intentional inflicting, or attempted or threatened inflicting, of serious injury upon the person of another. Although aggravated assault and simple assault are standard terms for reporting purposes, most state penal codes use labels such as first degree and second degree to make such distinctions. Aggravating circumstances. Circumstances relating to the commission of a crime that make it more grave than the average instance of that crime. Alibi. A statement or contention by an individual charged with a crime that he or she was so distant when the crime was committed, or so engaged in other provable activities, that his or her participation in the commission of that crime was impossible. Alter ego rule. In some jurisdictions, a rule of law that holds that a person can only defend a third party under circumstances and only to the degree that the third party could legally act on his or her own behalf. Alternative sentencing. The use of court-ordered community service, home detention, day reporting, drug treatment, psychological counseling, victim offender programming, or intensive supervision in lieu of other, more traditional sanctions, such as imprisonment and fines. Anticipatory warrant. A search warrant issued on the basis of probable cause to believe that evidence of a crime, although not currently at the place described, will likely be there when the warrant is executed. Appeal. The request that a court with appellate jurisdiction review the judgment, decision, or order of a lower court and set it aside, reverse it, or modify it. Appellate jurisdiction. The lawful authority of a court to review a decision made by a lower court. Arraignment. Strictly, the hearing before a court having jurisdiction in a criminal case in which the identity of the defendant is established, the defendant is informed of the charge and of his or her rights, and the defendant is required to enter a plea. Also, in some usages, any appearance in criminal court before trial. Arrest. The act of taking an adult or juvenile into physical custody by authority of law for the purpose of charging the person with a criminal offense, a delinquent act, or a status offense, terminating with the recording of a specific offense. Arson, UCR/NIBRS. Any willful or malicious burning or attempt to burn, with or without intent to defraud, a dwelling house, public building, motor vehicle or aircraft, personal property of another, and so on. Some instances of arson result from malicious mischief, some involve attempts to claim insurance money, and some are committed in an effort to disguise other crimes, such as murder, burglary, or larceny. Assault, UCR/NIBRS. An unlawful attack by one person upon another. Historically, assault meant only the attempt to inflict injury on another person. A completed act constituted the separate offense of battery. Under modern statistical usage, however, attempted and completed acts are grouped together under the generic term assault. Attendant circumstances. The facts surrounding an event. Bail. The money or property pledged to the court or actually deposited with the court to effect the release of a person from legal custody. Bail bond. A document guaranteeing the appearance of a defendant in court as required and recording the pledge of money or property to be paid to the court if he or she does not appear. The bail bond is signed by the person to be released and by anyone else acting in his or her behalf. Bailiff. The court officer whose duties are to keep order in the courtroom, to secure witnesses, and to maintain physical custody of the jury. Balancing test. A principle, developed by the courts and applied to the corrections arena by Pell v. Procania, that attempts to weigh the rights of an individual, as guaranteed by the Constitution, against the authority of any state to make laws or to otherwise restrict a person's freedom in order to protect the state's interests and its citizens. Bill of Rights. The popular name given to the first 10 amendments to the U.S. Constitution, which are considered especially important in the processing of criminal defendants. Biological weapon. A biological agent used to threaten human life, for example, anthrax, smallpox, or any infectious disease. Plus. Bivens action. A civil suit, based on the case of Bivens v. 6 unknown federal agents, brought against federal government officials for denying the constitutional rights of others. Blended sentence. A juvenile court disposition that imposes both a juvenile sanction and an adult criminal sentence on an adjudicated delinquent. The adult sentence is suspended on the condition that the juvenile offender successfully completes the term of the juvenile disposition and refrains from committing any new offense. 4. Broken windows. A model of policing based on the notion that physical decay, such as litter and abandoned buildings, can breed disorder in a community and can lead to crime by signaling that laws are not being enforced. The broken windows theory suggests that by encouraging the repair of run-down buildings and controlling disorderly behavior in public spaces, police agencies can create an environment in which serious crime cannot easily flourish. Bureau of Justice Statistics, BJS. A U.S. Department of Justice agency responsible for the collection of criminal justice data, including the annual National Crime Victimization Survey. Burglary, UCR/NIBRS. The unlawful entry of a structure to commit a felony or a theft, excludes tents, trailers, and other mobile units used for recreational purposes. Under the UCR/NIBRS program, the crime of burglary can be reported if an unlawful entry of an unlocked structure has occurred, a breaking and entering of a secured structure has taken place, or a burglary has been attempted. Capital offense. A criminal offense punishable by death. Capital punishment. The death penalty. Capital punishment is the most extreme of all sentencing options. Case law. The body of judicial precedent, historically built on legal reasoning and past interpretations of statutory laws, that serves as a guide to decision-making, especially in the courts. Caseload. The number of probation or parole clients assigned to one probation or parole officer for supervision. Chain of command. The unbroken line of authority that extends through all levels of an organization, from the highest to the lowest. Change of venue. The movement of a trial or lawsuit from one jurisdiction to another or from one location to another within the same jurisdiction. A change of venue may be made in a criminal case to ensure that the defendant receives a fair trial. Circumstantial evidence. The evidence that requires interpretation or that requires a judge or jury to reach a conclusion based on what the evidence indicates. From the close proximity of the defendant to a smoking gun, for example, the jury might conclude that he or she pulled the trigger. Civil death. The legal status of prisoners in some jurisdictions who are denied the opportunity to vote, hold public office, marry, or enter into contracts by virtue of their status as incarcerated felons. Although civil death is primarily of historical interest, some jurisdictions still limit the contractual opportunities available to inmates. Civil justice. The civil law, the law of civil procedure, and the array of procedures and activities having to do with private rights and remedies sought by civil action. Civil justice cannot be separated from social justice because the justice enacted in our nation's civil courts reflects basic American understandings of right and wrong. Civil law. The branch of modern law that governs relationships between parties. Civil liability. The potential responsibility for payment of damages or other court-ordered enforcement as a result of a ruling in a lawsuit. Civil liability is not the same as criminal liability, which means open to punishment for a crime. 5. Classification system. A system used by prison administrators to assign inmates to custody levels based on offense history, assessed dangerousness, perceived risk of escape, and other factors. Clearance rate. A measure of investigative effectiveness that compares the number of crimes reported or discovered to the number of crimes solved through arrest or other means, such as the death of the suspect. Closing argument. An oral summation of a case presented to a judge, or to a judge and jury, by the prosecution or by the defense in a criminal trial. Common law. The body of law originating from usage and custom rather than from written statutes. The term refers to an unwritten body of judicial opinion, originally developed by English courts, that is based on non-statutory customs, traditions, and precedents that help guide judicial decision-making. Community corrections. The use of a variety of officially ordered program-based sanctions that permit convicted offenders to remain in the community under conditional supervision as an alternative to an active prison sentence. Community court. A low-level court that focuses on quality-of-life crimes that erode a neighborhood's morale, that emphasizes problem-solving rather than punishment, and that builds on restorative principles such as community service and restitution. Community policing. A philosophy that promotes organizational strategies, which support the systematic use of partnerships and problem-solving techniques, to proactively address the immediate conditions that give rise to public safety issues such as crime, social disorder, and fear of crime. 6. Community service. A sentencing alternative that requires offenders to spend at least part of their time working for a community agency. Compelling interest. A legal concept that provides a basis for suspicionless searches when public safety is at issue. In 2 cases, the U.S. Supreme Court held that public safety may sometimes provide a sufficiently compelling interest to justify limiting an individual's right to privacy. Competent to stand trial. A finding by a court, when the defendant's sanity at the time of trial is at issue, that the defendant has sufficient present ability to consult with his or her attorney with a reasonable degree of rational understanding and that the defendant has a rational as well as factual understanding of the proceedings against him or her. CompStat. A crime analysis and police management process built on crime mapping that was developed by the New York City Police Department in the mid-1990s. Computer crime. Any crime perpetrated through the use of computer technology. Also, any violation of a federal or state computer crime statute. Also called cybercrime. Computer virus. A computer program designed to secretly invade systems and either modify the way in which they operate or alter the information they store. Viruses are destructive software programs that may effectively vandalize computers of all types and sizes. Concurrence. The coexistence of an act in violation of the law and a culpable mental state. Concurrent sentence. One of two or more sentences imposed at the same time, after conviction for more than one offense, and served at the same time. Also, a new sentence for a new conviction, imposed upon a person already under sentence for a previous offense, which is served at the same time as the previous sentence. Conditional release. The release of an inmate from prison to community supervision with a set of conditions for remaining on parole. If a condition is violated, the individual can be returned to prison or face another sanction in the community. 7. Conditions of parole, probation. The general and special limits imposed on an offender who is released on parole, or probation. General conditions tend to be fixed by state statute, whereas special conditions are mandated by the sentencing authority, court or board, and take into consideration the background of the offender and the circumstances of the offense. Conflict model. A criminal justice perspective that assumes that the system's components function primarily to serve their own interests. According to this theoretical framework, justice is more a product of conflicts among agencies within the system than it is the result of cooperation among component agencies. Consecutive sentence. One of two or more sentences imposed at the same time, after conviction for more than one offense, and served in sequence with the other sentence. Also, a new sentence for a new conviction, imposed upon a person already under sentence for a previous offense, which is added to the previous sentence, thus increasing the maximum time the offender may be confined or under supervision. Consensus model. A criminal justice perspective that assumes that the system's components work together harmoniously to achieve the social product we call justice. Corporate crime. A violation of a criminal statute by a corporate entity or by its executives, employees, or agents acting on behalf of and for the benefit of the corporation, partnership, or other form of business entity. Corpus delicti. The facts that show that a crime has occurred. The term literally means the body of the crime. Court of last resort. The court authorized by law to hear the final appeal on a matter. Courts of general jurisdiction. Courts of law with primary jurisdiction on all issues not delegated to lower courts. Most often called major trial courts, they most often hear serious criminal or civil cases. Cases are also designated to courts of general jurisdiction based on the severity of the punishment or allegation or on the dollar value of the case. Courts of limited jurisdiction. Courts of law that have jurisdiction on a restricted range of cases, primarily lesser criminal and civil matters, including misdemeanors, small claims, traffic, parking, and civil infractions. Such courts are also called inferior courts or lower courts. They can also handle the preliminary stages of felony cases in some states' treatment or care program administered by a non-justice or private agency. Also, a release without referral. Domestic terrorism. The unlawful use of force or violence by a group or an individual who is based and operates entirely within the United States and its territories without foreign direction and whose acts are directed at elements of the U.S. government or population. 14. Double jeopardy. A common law and constitutional prohibition against a second trial for the same offense. Due process. A right guaranteed by the 4th, 5th, 6th, and 14th Amendments of the U.S. Constitution and generally understood, in legal contexts, to mean the due course of legal proceedings according to the rules and forms established for the protection of individual rights. In criminal proceedings, due process of law is generally understood to include the following basic elements: a law creating and defining the offense, an impartial tribunal having jurisdictional authority over the case, accusation in proper form, notice and opportunity to defend, a trial according to established procedure, and discharge from all restraints or obligations unless convicted. Due process model. A criminal justice perspective that emphasizes individual rights at all stages of justice system processing. Electronic Communications Privacy Act, ECPA. A law passed by Congress in 1986 establishing the due process requirements that law enforcement officers must meet in order to legally intercept wire communications. Electronic evidence. Information and data of investigative value that are stored in or transmitted by an electronic device. Element of a crime. In a specific crime, one of the essential features of that crime, as specified by law or statute, emergency search. A search conducted by the police without a warrant, which is justified on the basis of some immediate and overriding need, such as public safety, the likely escape of a dangerous suspect, or the removal or destruction of evidence, entrapment and improper or illegal inducement to crime by agents of law enforcement. Also, a defense that may be raised when such inducements have occurred. Equity. A sentencing principle, based on concerns with social equality, holding that similar crimes should be punished with the same degree of severity, regardless of the social or personal characteristics of the offenders. Espionage, the gathering, transmitting, or losing of information related to the national defense in such a manner that the information becomes available to enemies of the United States and may be used to their advantage. European Police Office, Europol. The integrated police intelligence gathering and information disseminating arm of the member nations of the European Union. Evidence. Anything useful to a judge or jury in deciding the facts of a case. Evidence may take the form of witness testimony, written documents, videotapes, magnetic media, photographs, physical objects, and so on. Evidence-based corrections, EBC. The application of social scientific techniques to the study of everyday corrections procedures for the purpose of increasing effectiveness and enhancing the efficient use of available resources. Evidence-based policing, EBP. The use of the best available research on the outcomes of police work to implement guidelines and evaluate agencies, units, and officers. Point 17. Evidence-based practice. Crime-fighting strategies that have been scientifically tested and are based on social science research. Ex post facto. Latin for after the fact. The Constitution prohibits the enactment of ex post facto laws, which make acts committed before the laws in question were passed punishable as crimes. Excessive force. The application of an amount or frequency of force greater than that required to compel compliance from a willing or unwilling subject. Point 18. Exclusionary rule. The understanding, based on U.S. Supreme Court precedent, that incriminating information must be seized according to constitutional specifications of due process or it will not be allowed as evidence in a criminal trial. Exculpatory evidence. Any information having a tendency to clear a person of guilt or blame. Excuse. A legal defense in which the defendant claims that some personal condition or circumstance at the time of the act was such that he or she should not be held accountable under the criminal law. Expert witness. A person who has special knowledge and skills recognized by the court as relevant to the determination of guilt or innocence. Unlike lay witnesses, expert witnesses may express opinions or draw conclusions in their testimony. Federal court system. The three-tiered structure of federal courts, comprising U.S. District Courts, U.S. Courts of Appeals, and the U.S. Supreme Court. Felony. A criminal offense punishable by death or by incarceration in a prison facility for at least 1 year. First appearance. An appearance before a magistrate during which the legality of the defendant's arrest is initially assessed and the defendant is informed of the charges on which he or she is being held. At this stage in the criminal justice process, bail may be set or pretrial release arranged. Also called initial appearance. Fleeting targets exception. An exception to the exclusionary rule that permits law enforcement officers to search a motor vehicle based on probable cause but without a warrant. The fleeting targets exception is predicated on the fact that vehicles can quickly leave the jurisdiction of a law enforcement agency. Fruit of the poisonous tree doctrine. A legal principle that excludes from introduction at trial any evidence later developed as a result of an illegal search or seizure. Fusion Center. A multi-agency law enforcement facility designed to enhance cooperative efforts through a coordinated process for collecting, sharing, and analyzing information in order to develop actionable intelligence. Gain time. The amount of time deducted from time to be served in prison on a given sentence as a result of participation in special projects or programs. Gender responsiveness. The process of understanding and taking into account the differences in characteristics and life experiences that women and men bring to the criminal justice system, and adjusting strategies and practices in ways that appropriately respond to those conditions. General deterrence. A goal of criminal sentencing that seeks to prevent others from committing crimes similar to the one for which a particular offender is being sentenced by making an example of the person sentenced. Good time. The amount of time deducted from time to be served in prison on a given sentence as a result of good behavior. Good faith exception. An exception to the exclusionary rule. Law enforcement officers who conduct a search or who seize evidence on the basis of good faith, i.e., when they believe they are operating according to the dictates of the law, and who later discover that a mistake was made, perhaps in the format of the application for a search warrant, may still use the seized evidence in court. Grand jury. A group of jurors who have been selected according to law and have been sworn to hear the evidence and to determine whether there is sufficient evidence to bring the accused person to trial, to investigate criminal activity generally, or to investigate the conduct of a public agency or official. Grievance procedure. A formalized arrangement, usually involving a neutral hearing board, whereby institutionalized individuals have the opportunity to register complaints about the conditions of their confinement. Guilty but mentally ill, GBMI. A verdict, equivalent to a finding of guilty, that establishes that the defendant, although mentally ill, was in sufficient possession of his or her faculties to be morally blameworthy for his or her acts. Hands-off doctrine. A policy of non-intervention with regard to prison management that U.S. courts tended to follow until the late 1960s. For 30 years, the doctrine languished as judicial intervention in prison administration dramatically increased, although there is now evidence that a new hands-off era is beginning. Hate crime, UCR/NIBRS. A criminal offense committed against a person, property, or society that is motivated, in whole or in part, by the offender's bias against a race, religion, disability, sexual orientation, or ethnicity/national origin. Hearsay. Something that is not based on the personal knowledge of a witness. Witnesses who testify about something they have heard, for example, are offering hearsay by repeating information about a matter of which they have no direct knowledge. Hearsay rule. The long-standing precedent that hearsay cannot be used in American courtrooms. Rather than accepting testimony based on hearsay, the court will ask that the person who was the original source of the hearsay information be brought in to be questioned and cross-examined. Exceptions to the hearsay rule may occur when the person with direct knowledge is dead or is otherwise unable to testify. Home confinement. House arrest. Individuals ordered confined to their homes are sometimes monitored electronically to ensure they do not leave during the hours of confinement. Absence from the home during working hours is often permitted. Hotspot policing. A contemporary policing strategy in which law enforcement agencies focus their resources on known areas of criminal activity. Hudud crime, a serious violation of Islamic law that is regarded as an offense against God. Human smuggling. Illegal immigration in which an agent is paid to help a person cross a border clandestinely. Identity theft. A crime in which an impostor obtains key pieces of information, such as social security and driver's license numbers, to obtain credit, merchandise, and services in the name of the victim. The victim is often left with a ruined credit history and the time-consuming and complicated task of repairing the financial damage. 19. Illegally seized evidence. Any evidence seized without regard to the principles of due process as described by the Bill of Rights. Most illegally seized evidence is the result of police searches conducted without a proper warrant or of improperly conducted interrogations. Incapacitation. The use of imprisonment or other means to reduce the likelihood that an offender will commit future offenses, inchoate. Incompetent to stand trial. In criminal proceedings, a finding by a court that as a result of mental illness, defect, or disability, a defendant is incapable of understanding the nature of the charges and proceedings against him or her, of consulting with an attorney, and of aiding in his or her own defense. Indeterminate sentencing. A model of criminal punishment that encourages rehabilitation through the use of general and relatively unspecific sentences, such as a term of imprisonment of from 1 to 10 years. Indictment. A formal written accusation submitted to the court by a grand jury alleging that a specified person has committed a specified offense, usually a felony. Individual rights. The rights guaranteed to all members of American society by the U.S. Constitution, especially those rights found in the first 10 amendments to the Constitution, known as the Bill of Rights. These rights are particularly important to criminal defendants facing formal processing by the criminal justice system. Individual rights advocate. One who seeks to protect personal freedoms within the process of criminal justice. Information. A formal written accusation submitted to a court by a prosecutor, alleging that a specified person has committed a specified offense. Infraction. A minor violation of state statute or local ordinance punishable by a fine or other penalty or by a specified, usually limited, term of incarceration. Inherent coercion. The tactics used by police interviewers that fall short of physical abuse but that nonetheless pressure suspects to divulge information. Initial appearance. See first appearance. Insanity defense. A legal defense based on claims of mental illness or mental incapacity, intake the first step in decision-making regarding a juvenile whose behavior or alleged behavior is in violation of the law or could otherwise cause a juvenile court to assume jurisdiction. Intelligence-led policing, ILP. The collection and analysis of information to produce an intelligence end product designed to inform police decision-making at both the tactical and strategic levels. Point 20. Intensive probation supervision, IPS. A form of probation supervision involving frequent face-to-face contact between the probationer and the probation officer. Intermediate sanctions. The use of split sentencing, shock probation or parole, shock incarceration, mixed sentencing, community service, intensive probation supervision, or home confinement in lieu of other, more traditional sanctions, such as imprisonment and fines. Internal affairs. The branch of a police organization tasked with investigating charges of wrongdoing involving members of the department. International Criminal Police Organization, Interpol. An international law enforcement support organization that began operations in 1946 and today has 182 member nations. International Justice and Public Safety Information Sharing Network, NLETS. An important law enforcement information sharing resource that includes state criminal histories, Homeland Alert messages, immigration databases, driver's records and vehicle registrations, aircraft registrations, Amber Alerts, weather advisories, and hazardous materials, HAZMAT, notifications and regulations. International terrorism. The unlawful use of force or violence by a group or an individual who has some connection to a foreign power or whose activities transcend national boundaries against people or property in order to intimidate or coerce a government, the civilian population, or any segment thereof in furtherance of political or social objectives. Point 21. Interrogation. The information gathering activity of police officers that involves the direct questioning of suspects. Islamic law. A system of laws, operative in some Arab countries, based on the Muslim religion and especially the Holy Book of Islam, the Quran. Jail. A confinement facility administered by an agency of local government, typically a law enforcement agency, intended for adults but sometimes also containing juveniles. Jails hold people who are being detained pending adjudication or who were committed after adjudication, usually those sentenced to a year or less. Judge. An elected or appointed public official who presides over a court of law and who is authorized to hear and sometimes to decide cases and to conduct trials. Judicial review. The power of a court to review actions and decisions made by other agencies of government. Jurisdiction. The territory, subject matter, or people over which a court or other justice agency may exercise lawful authority, as determined by statute or constitution. Jurisprudence. The philosophy of law. Also, the science and study of the law. Juror. A member of a trial or grand jury who has been selected for jury duty and is required to serve as an arbiter of the facts in a court of law. Jurors are expected to render verdicts of guilty or not guilty as to the charges brought against the accused, although they may sometimes fail to do so, as in the case of a hung jury. Jury selection. The process whereby, according to law and precedent, members of a particular trial jury are chosen. Just deserts. A model of criminal sentencing that holds that criminal offenders deserve the punishment they receive at the hands of the law and that punishments should be appropriate to the type and severity of the crime committed. Justice. The principle of fairness, the ideal of moral equity. Justice model. A contemporary model of imprisonment based on the principle of just deserts. Justice reinvestment. A concept that prioritizes the use of alternatives to incarceration for persons convicted of eligible nonviolent offenses, standardizes the use of risk assessments instruments in pretrial detention, authorizes the use of early release mechanisms for prisoners who meet eligibility requirements, and reinvests savings from such initiatives into effective crime prevention programs. Justification. A legal defense in which the defendant admits to committing the act in question but claims it was necessary in order to avoid some greater evil. Juvenile. A youth at or below the upper age of juvenile court jurisdiction in a particular state. Juvenile court. Any court that has jurisdiction over matters involving juveniles. Juvenile disposition. The decision of a juvenile court that concludes a dispositional hearing. The adjudicated juvenile might be committed to a juvenile correctional facility, be placed in a juvenile residence, shelter, or care or treatment program, be required to meet certain standards of conduct, or be released. Juvenile justice system. The government agencies that function to investigate, supervise, adjudicate, care for, or confine youthful offenders and other children subject to the jurisdiction of the juvenile court. Juvenile petition. A document filed in juvenile court alleging that a juvenile is a delinquent, a status offender, or a dependent and asking that the court assume jurisdiction over the juvenile or that an alleged delinquent be transferred to a criminal court for prosecution as an adult. Kansas City experiment. The first large-scale scientific study of law enforcement practices. Sponsored by the Police Foundation, it focused on the practice of preventive patrol. Knapp Commission. A committee that investigated police corruption in New York City in the early 1970s. Landmark case. A precedent-setting court decision that produces substantial changes both in the understanding of the requirements of due process and in the practical day-to-day operations of the justice system. Larceny theft, UCR/N. IBRS. The unlawful taking or attempted taking, carrying, leading, or riding away of property, from the possession or constructive possession of another. Motor vehicles are excluded. Larceny is the most common of the 8 major offenses, although probably only a small percentage of all larcenies is actually reported to the police because of the small dollar amounts involved. Latent evidence. Evidence of relevance to a criminal investigation that is not readily seen by the unaided eye. Law. A rule of conduct, generally found enacted in the form of a statute, that proscribes or mandates certain forms of behavior. Law Enforcement Assistance Administration, LEAA. A now-defunct federal agency established under Title I of the Omnibus Crime Control and Safe Streets Act of 1968 to funnel federal funding to state and local law enforcement agencies. Lay witness. An eyewitness, character witness, or other person called on to testify who is not considered an expert. Lay witnesses must testify to facts only and may not draw conclusions or express opinions. Legal cause. A legally recognizable cause. A legal cause must be demonstrated in court in order to hold an individual criminally liable for causing harm. Legalistic style. A style of policing marked by a strict concern with enforcing the precise letter of the law. Legalistic departments may take a hands-off approach to disruptive or problematic behavior that does not violate the criminal law. Less lethal weapon. A weapon that is designed to disable, capture, or immobilize but not kill a suspect. Occasional deaths do result from the use of such weapons, however. Line operations. In police organizations, the field activities or supervisory activities directly related to day-to-day police work. Malware. Malicious computer programs such as viruses, worms, and Trojan horses. Mandatory release. The release of an inmate from prison that is determined by statute or sentencing guidelines and is not decided by a parole board or other authority. Point 22. Mandatory sentencing. A structured sentencing scheme that allows no leeway in the nature of the sentence imposed. Under mandatory sentencing, clearly enumerated punishments are mandated for specific offenses or for habitual offenders convicted of a series of crimes. Medical parole. An early release option under which an inmate who is deemed low risk due to a serious physical or mental health condition is released from prison earlier than he or she might have been under normal circumstances. Mens rea, the state of mind that accompanies a criminal act. Also, a guilty mind. Miranda triggers. The dual principles of custody and interrogation, both of which are necessary before an advisement of rights is required. Miranda warnings. The advisement of rights due criminal suspects by the police before questioning begins. Miranda warnings were first set forth by the U.S. Supreme Court in the 1966 case of Miranda v. Arizona. Misdemeanor. An offense punishable by incarceration, usually in a local confinement facility, for a period whose upper limit is prescribed by statute in a given jurisdiction, typically 1 year or less. Mitigating circumstances. Circumstances relating to the commission of a crime that may be considered to reduce the blameworthiness of the offender. Mixed sentence. A sentence that requires that a convicted offender serve weekends, or other specified periods of time, in a confinement facility, usually a jail, while undergoing probationary supervision in the community. M'Naughton rule. A rule for determining insanity that asks whether the defendant knew what he or she was doing or whether the defendant knew that what he or she was doing was wrong. Motive. A person's reason for committing a crime. Motor vehicle theft, UCR/NIBRS. The theft or attempted theft of a motor vehicle. Motor vehicle is defined as a self-propelled road vehicle that runs on land surface and not on rails. The stealing of trains, planes, boats, construction equipment, and most farm machinery is classified as larceny under the UCR/NIBRS program, not as motor vehicle theft. Multiculturalism. The existence within one society of diverse groups that maintain unique cultural identities while frequently accepting and participating in the larger society's legal and political systems. Multiculturalism is often used in conjunction with the term diversity to identify many distinctions of social significance. Municipal Police Department. A city or town-based law enforcement agency. Murder. The unlawful killing of a human being. Murder is a generic term that in common usage may include first and second-degree murder, manslaughter, involuntary manslaughter, and other similar offenses. National Crime Victimization Survey, NCVS. An annual survey of selected American households conducted by the Bureau of Justice Statistics to determine the extent of criminal victimization, especially unreported victimization in the United States. National Incident-Based Reporting System, NIBRS. An incident-based reporting system that collects detailed data on every single crime occurrence. NIBRS data are replacing the kinds of summary data that have traditionally been provided by the FBI's Uniform Crime Reporting Program. Neglected child. A child who is not receiving the proper level of physical or psychological care from his or her parents or guardians, or who has been placed up for adoption in violation of the law. 1983 lawsuit. A civil suit brought under Title 42, Section 1983, of the U.S. Code against anyone who denies others their constitutional right to life, liberty, or property without due process of law. NLETS. See International Justice and Public Safety Information Sharing Network. Nolo contendere. A plea of no contest. A no contest plea is used when the defendant does not wish to contest conviction. Because the plea does not admit guilt, however, it cannot provide the basis for later civil suits that might follow a criminal conviction. Nothing works doctrine. The belief, popularized by Robert Martinson in the 1970s, that correctional treatment programs have had little success in rehabilitating offenders. Offense. An offense not yet completed. Also, an offense that consists of an action or conduct that is a step toward the intended commission of another offense. Opening statement. The initial statement of the prosecution or the defense, made in a court of law to a judge, or to a judge and jury, describing the facts that he or she intends to present during trial to prove the case. Operational capacity. The number of inmates a prison can effectively accommodate based on management considerations, organized crime, the unlawful activities of the members of a highly organized, disciplined association engaged in supplying illegal goods or services, including gambling, prostitution, loan sharking, narcotics, and labor racketeering, and in other unlawful activities. Point 24. Original jurisdiction. The lawful authority of a court to hear or to act on a case from its beginning and to pass judgment on the law and the facts. The authority may be over a specific geographic area or over particular types of cases. Parens patriae. A common law principle that allows the state to assume a parental role and to take custody of a child when he or she becomes delinquent, is abandoned, or is in need of care that the natural parents are unable or unwilling to provide. Parole. A period of conditional supervised release in the community following a prison term. The term applies to parolees released through discretionary or mandatory supervised release from prison, those released through other types of post-custody conditional supervision, and those sentenced to a term of supervised release. Parole Board. A state paroling authority. Many states have parole boards that decide when an incarcerated offender is ready for conditional release. Some boards also function as revocation hearing panels. Parole, probation, violation. An act or a failure to act by a parolee, or probationer, that does not conform to the conditions of his or her parole, or probation. Parole revocation. The administrative action of a paroling authority removing a person from parole status in response to a violation of lawfully required conditions of parole, including the prohibition against committing a new offense, and usually resulting in a return to prison. Part I. Offenses. A UCR/NIBRS offense group used to report murder, rape, robbery, aggravated assault, burglary, larceny, theft, motor vehicle theft, and arson, as defined under the FBI's UCR/NIBRS program. Part 2. Offenses. A UCR/NIBRS offense group used to report arrests for less serious offenses. Agencies are limited to reporting only arrest information for Part 2 offenses, with the exception of simple assault. Peace Officer Standards and Training, POST, Program. The official program of a state or legislative jurisdiction that sets standards for the training of law enforcement officers. All states set such standards, although not all use the term POST. Penal Code. The written, organized, and compiled form of the criminal laws of a jurisdiction. Penal law. See criminal law. Peremptory challenge. The right to challenge a potential juror without disclosing the reason for the challenge. Prosecutors and defense attorneys routinely use peremptory challenges to eliminate from juries individuals who, although they express no obvious bias, are thought to be capable of swaying the jury in an undesirable direction. Perjury. The intentional making of a false statement as part of the testimony by a sworn witness in a judicial proceeding on a matter relevant to the case at hand. Petty crime. See quality of life offense. Plain view. A legal term describing the ready visibility of objects that might be seized as evidence during a search by police in the absence of a search warrant specifying the seizure of those objects. To lawfully seize evidence in plain view, officers must have a legal right to be in the viewing area and must have cause to believe that the evidence is somehow associated with criminal activity. Plea. In criminal proceedings, the defendant's formal answer in court to the charge contained in a complaint, information, or indictment that he or she is guilty of the offense charged, is not guilty of the offense charged, or does not contest the charge. Plea bargaining. The process of negotiating an agreement among the defendant, the prosecutor, and the court as to an appropriate plea and associated sentence in a given case. Plea bargaining circumvents the trial process and dramatically reduces the time required for the resolution of a criminal case. Police-community relations, PCR. An area of police activity that recognizes the need for the community and the police to work together effectively and is based on the notion that the police derive their legitimacy from the community they serve. Many police agencies began to explore PCR in the 1960s and 1970s. Police corruption. The abuse of police authority for personal or organizational gain. 25. Police discretion. The opportunity of law enforcement officers to exercise choice in their daily activities. Police ethics. The special responsibility to adhere to moral duty and obligation that is inherent in police work. Police management. The administrative activities of controlling, directing, and coordinating police personnel, resources, and activities in the service of crime prevention, the apprehension of criminals, the recovery of stolen property, and the performance of a variety of regulatory and helping services. Police professionalism. The increasing formalization of police work and the accompanying rise in public acceptance of the police. Police subculture. A particular set of values, beliefs, and acceptable forms of behavior characteristic of American police with which the police profession strives to imbue new recruits. Socialization into the police subculture commences with recruit training and continues thereafter. Police use of force. The use of physical restraint by a police officer when dealing with a member of the public. 26. Police working personality. All aspects of the traditional values and patterns of behavior evidenced by police officers who have been effectively socialized into the police subculture. Characteristics of the police personality often extend to the personal lives of law enforcement personnel. Precedent. A legal principle that ensures that previous judicial decisions are authoritatively considered and incorporated into future cases. Predictive policing. A contemporary policing strategy that uses statistical techniques to analyze data in order to anticipate or predict the likelihood of crime occurrence in locations of interest. Preliminary hearing. A proceeding before a judicial officer in which three matters must be decided: whether a crime was committed, whether the crime occurred within the territorial jurisdiction of the court, and whether there are reasonable grounds to believe that the defendant committed the crime. Pre-sentence investigation, PSI. The examination of a convicted offender's background prior to sentencing. Pre-sentence examinations are generally conducted by probation or parole officers and are submitted to sentencing authorities. Presumptive sentencing. A model of criminal punishment that meets the following conditions: the appropriate sentence for an offender convicted of a specific charge is presumed to fall within a range of sentences authorized by sentencing guidelines that are adopted by a legislatively created sentencing body, usually a sentencing commission. Sentencing judges are expected to sentence within the range or to provide written justification for failing to do so, and there is a mechanism for review, usually appellate, of any departure from the guidelines. Pretrial release. The release of an accused person from custody, for all or part of the time before or during prosecution, upon his or her promise to appear in court when required. Prison. A state or federal confinement facility that has custodial authority over adults sentenced to confinement. Prison argot. The slang that is characteristic of prison subculture and prison life. Prison capacity. The size of the correctional population an institution can effectively hold. There are three types of prison capacity: rated, operational, and design. Prison subculture. The values and behavioral patterns characteristic of prison inmates. Prison subculture has been found to be surprisingly consistent across the country. Prisoner reentry. The managed return to the community of individuals released from prison. Also called reentry. Prisonization. The process whereby newly institutionalized offenders come to accept prison lifestyles and criminal values. Although many inmates begin their prison experience with only a few values that support criminal behavior, the socialization experience they undergo while incarcerated leads to a much wider acceptance of such values. Private prison. A correctional institution operated by a private firm on behalf of a local or state government. Private protective services. The independent or proprietary commercial organizations that provide protective services to employers on a contractual basis. Privatization. The movement toward the wider use of private prisons. Probable cause. A set of facts and circumstances that would induce a reasonably intelligent and prudent person to believe that a particular other person has committed a specific crime. Also, reasonable grounds to make or believe an accusation. Probable cause refers to the necessary level of belief that would allow for police seizures, arrests, of individuals and full searches of dwellings, vehicles, and possessions. Probation. A sentence of imprisonment that is suspended. Also, a court-ordered period of correctional supervision in the community, generally as an alternative to incarceration. Probation revocation. A court order taking away a convicted offender's probationary status and usually withdrawing the conditional freedom associated with that status in response to a violation of the conditions of probation. Probative value. The degree to which a particular item of evidence is useful in, and relevant to, proving something important in a trial. Problem police officer. A law enforcement officer who exhibits problem behavior, as indicated by high rates of citizen complaints and use of force incidents and by other evidence. Point 28. Problem-solving policing. A type of policing that assumes that many crimes are caused by existing social conditions within the community and that crimes can be controlled by uncovering and effectively addressing underlying social problems. Problem-solving policing makes use of community resources, such as counseling centers, welfare programs, and job training facilities. It also attempts to involve citizens in crime prevention through education, negotiation, and conflict management. Procedural defense. A defense that claims that the defendant was in some significant way discriminated against in the justice process or that some important aspect of official procedure was not properly followed in the investigation or prosecution of the crime charged. Procedural fairness. The process by which procedures that feel fair to those involved are made. Procedural law. The part of the law that specifies the methods to be used in enforcing substantive law. Property bond. The setting of bail in the form of land, houses, stocks, or other tangible property. In the event that the defendant absconds before trial, the bond becomes the property of the court. Property crime. A UCR/NIBRS summary offense category that includes burglary, larceny, theft, motor vehicle theft, and arson. Proportionality. A sentencing principle that holds that the severity of sanctions should bear a direct relationship to the seriousness of the crime committed. Prosecutor. An attorney whose official duty is to conduct criminal proceedings on behalf of the state or the people against those accused of having committed criminal offenses. Prosecutorial discretion. The decision-making power of prosecutors, based on the wide range of choices available to them, in the handling of criminal defendants, the scheduling of cases for trial, the acceptance of negotiated pleas, and so on. The most important form of prosecutorial discretion lies in the power to charge, or not to charge, a person with an offense. Psychological manipulation. The manipulative actions by police interviewers, designed to pressure suspects to divulge information, that are based on subtle forms of intimidation and control. Public defender. An attorney employed by a government agency or sub-agency, or by a private organization under contract to a government body, for the purpose of providing defense services to indigents, or an attorney who has volunteered such service. Public order advocate. One who believes that under certain circumstances involving a criminal threat to public safety, the interests of society should take precedence over individual rights. Quality of life offense. A minor violation of the law, sometimes called a petty crime, that demoralizes community residents and businesspeople. Quality of life offenses involve acts that create physical disorder, for example, excessive noise and vandalism, or that reflect social decay, for example, panhandling and prostitution. Racial profiling. Any police-initiated action that relies on the race, ethnicity, national origin, sexual orientation, gender, or religion, rather than the behavior of an individual, or information that leads the police to a particular individual who has been identified as being, or having been, engaged in criminal activity. Rape, UCR/NIBRS. Unlawful sexual intercourse achieved through force and without consent. More specifically, penetration, no matter how slight, of the vagina or anus with any body part or object, or oral penetration by a sex organ of another person, without the consent of the victim. Statutory rape differs from other types of rape in that it generally involves non-forcible sexual intercourse with a minor. Broadly speaking, the term rape has been applied to a wide variety of sexual attacks and may include same-sex rape and the rape of a male by a female. Some jurisdictions refer to same-sex rape as sexual battery. Rated capacity. The number of inmates a prison can handle according to the judgment of experts. Real evidence. Evidence that consists of physical material or traces of physical activity. Realignment. A state government initiative designed to reduce prison populations. Under initiatives like California's Public Safety Realignment Program, for example, less serious offenders are sentenced to spend time in county jails rather than in state correctional facilities. Reasonable doubt. In legal proceedings, an actual and substantial doubt arising from the evidence, from the facts or circumstances shown by the evidence, or from the lack of evidence. Also, the state of a case such that, after the comparison and consideration of all the evidence, jurors cannot say they feel an abiding conviction of the truth of the charge. Reasonable doubt standard. The standard of proof necessary for conviction in criminal trials. Reasonable force. A degree of force that is appropriate in a given situation and is not excessive. Also, the minimum degree of force necessary to protect oneself, one's property, a third party, or the property of another in the face of a substantial threat. Reasonable suspicion. The level of suspicion that would justify an officer in making further inquiry or in conducting further investigation. Reasonable suspicion may permit stopping a person for questioning or for a simple pat-down search. Also, a belief, based on a consideration of the facts at hand and on reasonable inferences drawn from those facts, that would induce an ordinarily prudent and cautious person under the same circumstances to conclude that criminal activity is taking place or that criminal activity has recently occurred. Reasonable suspicion is a general and reasonable belief that a crime is in progress or has occurred, whereas probable cause is a reasonable belief that a particular person has committed a specific crime. Recidivism. The act of relapsing into a problem or criminal behavior during or after receiving sanctions, or while undergoing an intervention due to a previous behavior or crime. In criminal justice settings, recidivism is often measured by criminal acts that result in rearrest, reconviction, or return to prison. Recidivism rate, a measure of the rate of reoffending, usually defined by arrest, for a given population of released prisoners, or for a group of criminally sanctioned offenders, over time. Rates of recidivism are generally calculated over a 3 or a 5-year time period. Reckless behavior. An activity that increases the risk of harm, reentry. See prisoner reentry. Reentry courts. Specialized courts that help reduce recidivism and improve public safety through the use of judicial oversight to apply graduated sanctions and positive reinforcement, to marshal resources to support the prisoner's reintegration, and to promote positive behavior by the returning prisoners. Regional jail. A jail that is built and run using the combined resources of a variety of local jurisdictions. Rehabilitation. The attempt to reform a criminal offender. Also, the state in which a reformed offender is said to be. Release on recognizance, ROR. The pretrial release of a criminal defendant on his or her written promise to appear in court as required. No cash or property bond is required. Remote location monitoring. A supervision strategy that uses electronic technology to track offenders who are sentenced to house arrest or those who have been ordered to limit their movements while completing a sentence involving probation or parole. Restitution. A court requirement that an alleged or convicted offender pay money or provide services to the victim of the crime or provide services to the community. Restoration. A goal of criminal sentencing that attempts to make the victim whole again. Restorative justice, RJ. A sentencing model that builds on restitution and community participation in an attempt to make the victim whole again. Retribution. The act of taking revenge on a criminal perpetrator. Revocation hearing. A hearing held before a legally constituted hearing body, such as a parole board, to determine whether a parolee or probationer has violated the conditions and requirements of his or her parole or probation. Robbery, UCR/NIBRS. The unlawful taking or attempted taking of property that is in the immediate possession of another by force or violence and/or by putting the victim in fear. Armed robbery differs from unarmed, or strong-arm, robbery in that it involves a weapon. Contrary to popular conceptions, highway robbery does not necessarily occur on a street and rarely in a vehicle. The term highway robbery applies to any form of robbery that occurs outdoors in a public place. Rule of law. The maxim that an orderly society must be governed by established principles and known codes that are applied uniformly and fairly to all of its members. Rules of evidence. The court rules that govern the admissibility of evidence at criminal hearings and trials. Scientific jury selection. The use of correlational techniques from the social sciences to gauge the likelihood that potential jurors will vote for conviction or for acquittal. Scientific police management. The application of social sciences techniques to the study of police administration for the purpose of increasing effectiveness, reducing the frequency of citizen complaints, and enhancing the efficient use of available resources. Search incident to an arrest. A warrantless search of an arrested individual conducted to ensure the safety of the arresting officer. Because individuals placed under arrest may be in possession of weapons, courts have recognized the need for arresting officers to protect themselves by conducting an immediate search of arrestees without obtaining a warrant. Security Threat Group, STG. An inmate group, gang, or organization whose members act together to pose a threat to the safety of corrections staff or the public, who prey on other inmates, or who threaten the secure and orderly operation of a correctional institution. Selective incapacitation. A policy that seeks to protect society by incarcerating individuals deemed to be the most dangerous. Self-defense. The protection of oneself or of one's property from unlawful injury or from the immediate risk of unlawful injury. Also, the justification that the person who committed an act that would otherwise constitute an offense reasonably believed that the act was necessary to protect self or property from immediate danger. Sentencing. The imposition of a criminal sanction by a judicial authority. Sentinel event. A bad outcome that no one wants repeated and that signals the existence of underlying weaknesses in the system. Sequestered jury. A jury that is isolated from the public during the course of a trial and throughout the deliberation process. Service style. A style of policing marked by a concern with helping rather than strict enforcement. Service-oriented police agencies are more likely to refer citizens to community resources, such as drug treatment programs, than are other types of agencies. Sexual battery. the intentional and wrongful physical contact with a person, without his or her consent, that entails a sexual component or purpose. Sheriff. The elected chief officer of a county law enforcement agency. The sheriff is usually responsible for law enforcement in unincorporated areas and for the operation of the county jail. Shock incarceration. A sentencing option that makes use of boot camp type prisons to impress on convicted offenders the realities of prison life. Shock probation. The practice of sentencing offenders to prison, allowing them to apply for probationary release, and enacting such release in surprise fashion. Offenders who receive shock probation may not be aware that they will be released on probation and may expect to spend a much longer time behind bars. Smart policing. A law enforcement initiative that makes use of techniques shown to work at both reducing and solving crimes. Sneak and peek search. A search that occurs in the suspect's absence and without his or her prior knowledge. Also known as a delayed notification search. Social control. The use of sanctions and rewards within a group to influence and shape the behavior of individual members of that group. Social control is a primary concern of social groups and communities, and it is their interest in the exercise of social control that leads to the creation of both criminal and civil statutes. Social debt. A sentencing principle that holds that an offender's criminal history should objectively be taken into account in sentencing decisions. Social disorganization. A condition said to exist when a group is faced with social change, uneven development of culture, maladaptiveness, disharmony, conflict, and lack of consensus. Social justice. An ideal that embraces all aspects of civilized life and that is linked to fundamental notions of fairness and to cultural beliefs about right and wrong. Social order. The condition of a society characterized by social integration, consensus, smooth functioning, and lack of interpersonal and institutional conflict. Also, a lack of social disorganization. Spam. Unsolicited commercial bulk email whose primary purpose is the advertisement or promotion of a commercial product or service. Span of control. The number of police personnel or the number of units supervised by a particular officer. Specialized courts. Low-level courts that focus on relatively minor offenses and handles special populations or addresses special issues such as re-entry. Specialized courts are often a form of community courts. Specific deterrence. A goal of criminal sentencing that seeks to prevent a particular offender from engaging in repeat criminality. Speedy Trial Act. A 1974 federal law requiring that proceedings against a defendant in a criminal case begin within a specified period of time, such as 70 working days after indictment. Some states also have speedy trial requirements. Split sentence. A sentence explicitly requiring the convicted offender to serve a period of confinement in a local, state, or federal facility, followed by a period of probation. Staff operations. In police organizations, activities, such as administration and training, that provide support for line operations. Stalking. Repeated harassing and threatening behavior by one individual against another, aspects of which may be planned or carried out in secret. Stalking might involve following a person, appearing at a person's home or place of business, making harassing phone calls, leaving written messages or objects, or vandalizing a person's property. Most stalking laws require that the perpetrator make a credible threat of violence against the victim or members of the victim's immediate family. Stare decisis. A legal principle that requires that in subsequent cases on similar issues of law and fact, courts be bound by their own earlier decisions and by those of higher courts having jurisdiction over them. The term literally means standing by decided matters. State Court Administrator. A coordinator who assists with case flow management, operating funds budgeting, and court docket administration. State Court System. A state judicial structure. Most states generally have at least 3 court levels: trial courts, appellate courts, and a state Supreme Court. Status offender. A child who commits an act that is contrary to the law by virtue of the offender's status as a child. Purchasing cigarettes, buying alcohol, and being truant are examples of such behavior. Status offense. An act or conduct that is declared by statute to be an offense, but only when committed by or engaged in by a juvenile, and that can be adjudicated only by a juvenile court. Statutory law. The written or codified law, the law on the books, as enacted by a government body or agency having the power to make laws. Strategic policing. A type of policing that retains the traditional police goal of professional crime fighting but enlarges the enforcement target to include non-traditional kinds of criminals, such as serial offenders, gangs and criminal associations, drug distribution networks, and sophisticated white-collar and computer criminals. Strategic policing generally makes use of innovative enforcement techniques, including intelligence operations, undercover stings, electronic surveillance, and sophisticated forensic methods. Strict liability. A liability without fault or intention. Strict liability offenses do not require mens rea. Structured sentencing. A model of criminal punishment that includes determinate and commission-created presumptive sentencing schemes, as well as voluntary/advisory sentencing guidelines. Subpoena. A written order issued by a judicial officer or grand jury requiring an individual to appear in court and to give testimony or to bring material to be used as evidence. Some subpoenas mandate that books, papers, and other items be surrendered to the court. Substantive criminal law. The part of the law that defines crimes and specifies punishments. Suspicionless search. A search conducted by law enforcement personnel without a warrant and without suspicion. Suspicionless searches are permissible only if based on an overriding concern for public safety. Sworn officer. A law enforcement officer who is trained and empowered to perform full police duties, such as making arrests, conducting investigations, and carrying firearms. Tazir crime. A minor violation of Islamic law that is regarded as an offense against society, not God. Team policing. The reorganization of conventional patrol strategies into an integrated and versatile police team assigned to a fixed district. 29. Teen court. An alternative approach to juvenile justice in which alleged offenders are judged and/or sentenced by a jury of their peers. Terrorism. A violent act or an act dangerous to human life in violation of the criminal laws of the United States or of any state, committed to intimidate or coerce a government, the civilian population, or any segment thereof in furtherance of political or social objectives. 30. Testimony. The oral evidence offered by a sworn witness on the witness stand during a criminal trial. Tort. A wrongful act, damage, or injury not involving a breach of contract. Also, a private or civil wrong or injury. Total institution, an enclosed facility separated from society both socially and physically, where the inhabitants share all aspects of their daily lives. Trafficking in persons, tip. The exploitation of unwilling or unwitting people through force, coercion, threat, or deception. Transnational offenses. Unlawful activity that occurs across national boundaries. Transnational organized crime. Unlawful activity undertaken and supported by organized criminal groups operating across national boundaries. Treason. A U.S. citizens' actions to help a foreign government overthrow, make war against, or seriously injure the United States. Also, the attempt to overthrow the government of the society of which one is a member, trial in criminal proceedings, the examination in court of the issues of fact and relevant law in a case for the purpose of convicting or acquitting the defendant. Trial de novo. Literally, new trial. The term is applied to cases that are retried on appeal, as opposed to those that are simply reviewed on the record. Truth in sentencing. A close correspondence between the sentence imposed on an offender and the time actually served in prison. 32. Undisciplined child. A child who is beyond parental control, as evidenced by his or her refusal to obey legitimate authorities, such as school officials and teachers. Uniform Crime Reporting, UCR, Program. A statistical reporting program run by the FBI's Criminal Justice Information Services, CJIS, division. The UCR program publishes crime in the United States, which provides an annual summation of the incidence and rate of reported crimes throughout the United States. USA Patriot Act. A federal law, Public Law 107-56, enacted in response to terrorist attacks on the World Trade Center and the Pentagon on September 11, 2001. The law, officially titled the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act, substantially broadened the investigative authority of law enforcement agencies throughout America and is applicable to many crimes other than terrorism. The law was slightly revised and reauthorized by Congress in 2006. Verdict. The decision of the jury in a jury trial or of a judicial officer in a non-jury trial. Victim Impact Statement. An in-court statement made by the victim or by survivors to sentencing authorities seeking to make an informed sentencing decision. Victims Assistance Program. An organized program that offers services to victims of crime in the areas of crisis intervention and follow-up counseling and that helps victims secure their rights under the law. Violent crime. A UCR/NIBRS summary offense category that includes murder, rape, robbery, and aggravated assault. Voluntary/advisory sentencing guidelines. Recommended sentencing policies that are not required by law. Warehousing. An imprisonment strategy that is based on the desire to prevent recurrent crime and that has abandoned all hope of rehabilitation. Warrant. In criminal proceedings, a writ issued by a judicial officer directing a law enforcement officer to perform a specified act and affording the officer protection from damages if he or she performs it. Watchman style. A style of policing marked by a concern for order maintenance. Watchman policing is characteristic of lower-class communities where informal police intervention into the lives of residents is employed in the service of keeping the peace. White-collar crime. Financially motivated nonviolent crime committed by business and government professional. Workhouse. An early form of imprisonment whose purpose was to instill habits of industry in the idle. Writ of certiorari. A writ issued from an appellate court for the purpose of obtaining from a lower court the record of its proceedings in a particular case. In some states, this writ is the mechanism for discretionary review. A request for review is made by petitioning for a writ of certiorari, and the granting of review is indicated by the issuance of the writ. Writ of habeas corpus. A writ that directs the person detaining a prisoner to bring him or her before a judicial officer to determine the lawfulness of the imprisonment. Glossary GLL. 1. All boldface terms are explained whenever possible using definitions provided by the Bureau of Justice Statistics under a mandate of the Justice System Improvement Act of 1979. That mandate found its most complete expression in the Dictionary of Criminal Justice Data Terminology, the second edition of which provides the wording for many definitions in this text. 2. Adapted from references. All boldface terms are explained whenever possible using definitions provided by the Bureau of Justice Statistics under a mandate of the Justice System Improvement Act of 1979. That mandate found its most complete expression in the Dictionary of Criminal Justice Data Terminology, the second edition of which provides the wording for many definitions in this text. Adapted from U.S. Code, Title 28, Section 20.3, 2DJ. Title 28 of the U.S. Code defines the term administration of criminal justice. Technical Working Group on Crime Scene Investigation, Crime Scene Investigation, A Guide for Law Enforcement. p. 12. Howard N. Snyder and Melissa Sickmund, Juvenile Offenders and Victims, 2006 National Report. Adapted from Gerald Hill and Kathleen Hill, The Real Life Dictionary of the Law http://www.law.com. Office of Community Oriented Policing Services, Community Policing Defined, p3. Jeremy Travis and Sarah Lawrence, Beyond the Prison Gates, The State of Parole in America, p3. Michael L. Benson, Francis T. Cullen, and William J. Mockestad, Local Prosecutors and Corporate Crime, p1. Office of Justice Programs, the National Criminal Intelligence Sharing Plan, p27. Wayne W. Bennett and Karen M. Hess, Criminal Investigation, 6th ed. p3. Violence Against Women Office, Stalking and Domestic Violence, Report to Congress, p5. Sam W. Lathrop, Reviewing Use of Force, A Systematic Approach, FBI Law Enforcement Bulletin, p18. Adapted from Larry R. Liebrock, Overview and Impact on 21st Century Legal Practice, Digital Forensics and Electronic Discovery, no date, http://www.courtroom21net/fdic.pps